Welcome to this week's edition of The Legal Journal. Now, here's your host, Ross Brindle.
Good Saturday morning. You are listening to The Legal Journal on Business 1570. I'm Ross Brindle. Today in the studio, we are joined by Brian Rochel. He is with Halunen and Associates. Brian, good morning to you. It's good to see you.
It's great to be here, and thanks very much for having me on the show.
I want to get into a little bit about yourself and your background, and I could do a good job of it. I certainly could, but I'd like to ask you to just kind of talk a little bit about yourself and your background for our listeners.
Sure, no problem at all, Ross. I graduated from Halunen Law School here in the Twin Cities, 2010.
So a local boy, so to speak. You're one of us.
Indeed. I'm not a transplant. I actually went to Halunen for undergrad as well, so Halunen. And then I graduated in 2010, and I had been clerking for the law firm Halunen & Associates, and I have worked there as an attorney since graduating. Halunen & Associates is a firm dedicated to practicing employment and consumer law, and our employment law practice represents exclusively employees, so we only represent the employee on that side.
And I should mention, you have very big shoes to fill, because a few weeks back we had Susan Kohler who was in, and she spoke very highly of you off the air. We didn't talk much about yourself on the air, but she spoke very highly of you, and she was a very nice lady, and I can already tell you're probably just as nice as her. I guess the next hour will decide that, but just to let you know, you work with a pretty good person there in Susan Kohler. Again, it's the Legal Journal on Business 1570. Brian Rochel with Halunen & Associates. I'll get that right. If you want to comment today on the show, 651-289-4477. You can text as well, 651-243-0391. Dr. Bill Rubin is running the board today. He will be more than happy to take your text or your phone call if you would like to contribute. Again, it's the Legal Journal on Business 1570. Brian, very quickly, what does Halunen & Associates specialize in? What do they specialize in?
Halunen & Associates specializes in employment law. We represent employees, and then there's another part of our practice that represents consumers as well in a consumer practice. And you had mentioned Susan Kohler, who's sort of our expert on ketam or whistleblower cases as well.
It's one of my favorite words, by the way, already in doing this show, ketam. It's a fun word to say.
It's a great word.
Today we're talking about a lot of different things, including discrimination, harassment, things like retaliation, a lot of other things. In general, Brian, let's just talk about this. Seems to be something we talk about a fair amount on the show, but the answers tend to be a little bit different, which is so great that we have so many great experts in here to talk about things like this. Must an employer, so your boss, must they have a good reason to fire you, or can they just call you in one day and say, Tom, Bob, Jim, Jan, Susie, it's been a nice run, but we're letting you go? How does that work?
It's a great question, Ross, and the short answer is no. An employer does not have to have a good reason to fire you. In Minnesota, we live in what's called an at-will employment state, and what at-will employment means is that an employer can fire an employee generally for any reason that they want at any time. Doesn't have to be a good reason. And the flip side of that coin is that an employee can quit his or her employment at any other time without a good reason.
So essentially, you don't need a good reason at all, but maybe in the long run you probably should. I guess I'm just kind of theorizing in my opinion. You're probably helping yourself out as an employer if there actually is a reason versus just letting somebody go.
Exactly. You shouldn't really go around willy-nilly firing employees without a good reason. And we'll talk a little bit about some of those specifics as to why, because if you don't have a good reason, it might be indicative of discrimination or other bad things that you had mentioned at the beginning. I would also like to point out, too, that there are some exceptions to the at-will employment rule, including if you've signed a contract as an employee or if there's a union collective bargaining agreement in place.
And those would almost always be things you enter into beforehand, before your employment, right? So you would know about that going in.
That's exactly right.
How about this? What if you're fired for something that you perceive other employees maybe do all the time, but yet they don't get in trouble for it? Is that illegal?
Again, another great question, and again, the answer is generally speaking, no.
Okay.
An employer is not under any legal obligation to enforce its policies the exact same for every single employee. But what that would tell me, and I do have employees who contact me and tell me about a situation like that. And legally, it's not illegal to fire John because he was late and not fire Sally because when she was late. But it might be a sign that there's some type of discrimination going on.
That there might be other things going on with this case.
That's right.
How about this? Well, first, before we go into my next point, I want to let people know about the website for Halunen and Associates, HALUNEN law.com. That's HALUNEN law.com. Again, you're listening to the Legal Journal on Business 1570. Ross Brindle with you on this Saturday morning, as we are each and every Saturday morning at 9 o'clock. Don't forget, you can always listen online at business1570.com. Brian Rochel joins us this morning in studio. Brian, let's talk about wrongful discharge cases. What is that? Can you explain that in general, in layman's terms?
Sure. Wrongful discharge, what that means in layman's terms is when an employer terminates an employee and it's illegal. It violates some area of the law. And a wrongful discharge in Minnesota can generally be broken down into two categories. It's illegal for an employer to terminate an employee for a discriminatory reason. It's also illegal to do it for a retaliatory reason. Those are, generally speaking, the two major areas of wrongful discharge. Other than that, you're in the territory that we talked about before, where you can terminate an employee and not have a good reason, but it's not really illegal.
And those are things we're going to get into, things like retaliation, harassment, all that stuff. Let's start in general with discrimination, types of discrimination, now that we have a little bit more of a background on just essentially how somebody could get fired, if that's okay, if it's not okay. What if an employer treats you differently than other employees? I know we kind of touched on that, but you're still employed. Is that illegal discrimination? Is that something that you can basically go to work and say, well, I feel like it's wrong, but there's nothing I can do about it? Let's talk about that.
Yeah, the answer there, Ross, is it might be. And this is probably a good point to highlight that there really isn't an easy answer in a lot of these employment law claims, and it's always a good idea to seek legal advice if you think there's a question. But to speak directly to what you asked, if an employer treats a group of employees or a single employee differently, it's still not necessarily illegal unless the treatment is based on what's called a protected class or a protected status.
Can we talk about that briefly on maybe what that is?
Absolutely.
Can you elaborate on that a little bit?
Absolutely. A protected status is those are the areas that the law says you can't treat employees or people differently. And in Minnesota, the protected classes are race, color, creed, national origin, sex, marital status, disability, public assistance, age, and sexual orientation. So these are the types of things that you're generally used to hearing about being illegal discrimination.
You talked about race. You mentioned race in there. There's a lot of different things to talk about, but specifically on race. Minority friends, maybe they've told you they think their employers treat them differently, but they don't think that they can prove they're being discriminated against on the basis of maybe their race or their origin. How do you ever prove that? I mean, I imagine that it can be done, but it might be a little tricky, correct?
That's right. It can be. The easiest way to prove race discrimination is really when an employee knows that it's taking place. You have direct comments, racist actions, or remarks in the workplace. When that happens, it's pretty clear that race discrimination has taken place. But there are actually a lot of other ways to prove discrimination as well, even in the absence of that type of direct, invidious statement. There are indirect statements. For an example, you might hear somebody say, Joe will never understand the email system. He's just too old. I mean, that might be indicative of some type of ageism going on. Or differential treatment, where a subset of employees are treated differently than other employees. Or even statistical evidence. You see numerically different employees are being treated differently.
This morning on the Legal Journal, I'm joined by Brian Rochel. He is with Halunen and Associates, the website HALUNEN law.com. That's HALUNEN law.com. wrongfully.com. I want to continue, Brian, on some of these types of discrimination, what is, what isn't, and maybe just general backgrounds of what some of these are. What is the legal definition of a disability? And going along with that, if you feel like you're being discriminated because of that disability. So it probably helps to know what exactly the legal definition is and then move from there.
Yeah, that makes a lot of sense. The legal definition of disability can be a little bit confusing, so I'm glad that you asked that. The law defines it as an impairment, physical or mental, that substantially limits one or more major life activities. Now, what does that mean, right?
It's a little general.
Exactly.
It's a little general.
Exactly. And so
that's why we have you here to help us out a little bit.
And I'll do my best. The courts and the lawyers fight about this all the time, so it's sort of unsettled. But really what that means is you're looking at major life activities. That includes things that people do on a day-to-day basis or that are very important to just human living. Walking, sleeping, breathing, these are major life activities, arguably working. And so if there's a limitation on any of those things, you probably have a legal disability. Major life activity also includes major bodily functions. So there might be, cancer is a good example of something that's a disability.
I want to make sure we touch on all of these in general. So let me backtrack a little bit too. Let's say that you're a male and maybe you think your female boss treats you differently than all the female employees, or vice versa. Maybe you're a female, you think your male boss treats you differently. Can you be discriminated against in that generalization? But maybe more specifically, the thing we don't talk about maybe as much as others. We've talked about the female maybe thinks they're being discriminated against, but vice versa. Let's flip that around. What if you're a man and you feel like you're being discriminated against by a female boss? First and foremost, have you dealt with cases where maybe that's happened? I mean, is it common? Is it uncommon? And I guess in general, I mean, is there a case there?
Yeah, to answer that question, there is a case there. It is illegal. Sex discrimination is illegal regardless of whether you're male or female. And in fact, our firm has represented male employees who have been subject to not only sex discrimination but also sex harassment. And I think that it does occur, but maybe there is some type of stigma that might prevent people from raising that.
Brian, if people are listening today and they feel like anything we've talked about so far, anything that we will talk about, maybe they feel like they might want to reach out and talk to you, is the best way just to go to the website and start there and then maybe give Halunen and Associates a call? Is that the best way to do it, just by maybe starting with the website?
Yeah, I would encourage people to do that.
And that is halunenlaw.com, HALUNEN law.com, halunenlaw.com. You said maybe there's a stigma, but just because there's a stigma and maybe it makes you feel a little uncomfortable, that's probably maybe not a good enough reason to not act on something, correct?
Absolutely. I strongly encourage people to reach out, notwithstanding that stigma, because it is illegal again. And the same actually goes, Ross, for race discrimination as well. You can be discriminated against based on your race, even if you're Caucasian or white. It doesn't have to be a minority race. It protects all race discrimination.
Well, let's hop back. I get so excited doing this show. I jump all over the place, which is I think good because we get to cover a lot of ground. But then I'm going to circle back to something we touched on briefly with disabilities. Let's focus on that for a little bit, if you don't mind, now that we have a general synopsis of a lot of things that we're talking about. If you have a disability, is your employer required to help in any way? Do they have to make things more reasonable for you? And again, with that, it's kind of a two-part question. If they're not, do you have a case? Or maybe you don't have a case because maybe you're going to tell me they're not required to help you. So I guess let's start with that, and again, we'll move forward from there.
Exactly. And this is an important area. If you do have a disability, your employer is required to offer an accommodation. What the legal term there is reasonable accommodation. And what that's intended to mean is that the employer has to do what it can within reasonable boundaries to help the employee. And the employee has the burden or sort of it's incumbent upon them to let the employer know or make them aware that they need some type of accommodation.
Sure, and then in response to that, they would have to say, look, this is nice, but I need more, or this is not enough, or this is too much, right?
That's exactly right. And what you just described is what the law calls the interactive process. That's where the employer and the employee they're both in good faith working it out with each other.
There has to be a little give and take. The employer can't just hire you, think they're doing what's right, you never tell them, and then maybe a year later you're trying to bring charges against them, correct? I mean, that would be a little bit tough from your standpoint.
Exactly, that's right. As long as it's not an open and obvious disability, right, you have to do your part too.
Can an employer, straight up from the get-go, say you and I are doing a job interview, right away I find out beforehand, I looked at your resume, I said, oh boy, this Brian Rochel guy seems like he'd be great for us. Then you come in, maybe you disclose in an interview you have a disability, or maybe it's apparent, but I can just look at it and see it. Can I not hire you based off of that, even if everything else stacks up?
Absolutely not. An employer's decision not to hire an employee can't be motivated by a disability.
So then if you felt like the only reason you didn't get a job, maybe the best thing to do would be to call somebody and get maybe some legal consult, right? If you absolutely thought that was the case.
Exactly, and this sort of goes back to how do you prove it, and you mentioned it yourself, Ross. It might be that the employer didn't even know about your disability until they sat down and met with you, or you put it in a job application.
Okay.
That might indicate some type of intent there.
HalunenLaw.com, HALUNEN Law.com. You're listening to the Legal Journal on Business 1570. Ross Brindle with you once again on this Saturday morning. Brian Rochel joins us with Halunen and Associates. If the name is familiar, a few weeks back we were joined by Susan Kohler, who helped us out on a Saturday morning. Very good people in the work that they do at Halunen Law, protecting employees basically all across the Twin Cities. Again, HalunenLaw.com, HALUNEN Law.com. How about this? I'm gonna go with a little bit of a different approach here on this one. We are coming up on the holiday season, the Christmas season, Thanksgiving right around the corner. Actually, just 3 weeks away now, right around the corner. If you request time off for a religious holiday, so say you take, maybe you don't actually get Thanksgiving off, but you requested it off and you wind up working it, does your employer have to grant you the time off?
Generally speaking, no. You're not entitled to get time off for holidays. But you had the key term in there might be religious holiday. And there is a requirement that employees offer a religious accommodation, but it's a pretty limited requirement.
And that would be more, so to speak, we're talking Christmas, Hanukkah, things like that, correct?
Exactly.
Okay. What about beforehand, though? What if you're told, you enter into a verbal agreement at will, and you're told, here's your 8 days you get off, and you assume you have Christmas Day off, but a week beforehand your boss says, hey, I'm sorry, we're way behind, we got a really big project, I need you to come in Christmas Day for 3-4 hours. Can they do that?
That's a more complicated question. In most circumstances, yes, the employer can legally do that. There are some nuances there, so if that were to happen, I would encourage somebody to get legal advice about the specifics, but generally that still doesn't violate the law.
Okay, and the main type of discrimination we spent a teeny bit of time on, I know main's not the right word, but one of the portions that we didn't spend a ton of time on was basically age. What if your employer laid you off with a group of employees? They never said really anything about age, but all the employees who were laid off were older than maybe other employees who were kept. I got to imagine, based off of what I'm sensing from you so far in the opening of the show, that might be illegal, but again, you'd have to be able to prove that, correct?
That's exactly right.
I'm catching on to this stuff pretty quickly.
You're a bright kid, Ross.
Let's talk about that, if you don't mind.
Sure. That's actually a fairly common occurrence. Age discrimination, the statistics are showing that age discrimination has increased. The EEOC is reporting that. And what we see a lot of times when we're bringing an age discrimination case is exactly that type of scenario. It's just a statistical layoff thing. So you lay off 100 employees and 80 of them happen to be over the age of 55, but you're retaining all of the younger employees for those same positions.
Who might be doing the exact same type of work.
Exactly.
Okay.
Exactly.
We've mentioned an awful lot about all the types of discrimination, and I'm sure throughout the show we will circle back to them. Again, Brian Rochel joins us this morning. He is with Halunen and Associates, the website halunenlaw.com, HALUNEN law.com. Let's focus a little bit on harassment here in the final 6-7 minutes of this segment before we take a quick break. How far can an employer go before he or she is guilty of sexually harassing an employee? We talked about that a little bit with the male-female discrimination. But specifically, I got to imagine, and you've mentioned this already in the show, that there's not maybe really a set bar for this, correct?
That's absolutely right, and it's especially the case with sexual harassment. It can oftentimes be a question of degree. And what sexual harassment must be in order to violate the law is both objectively and subjectively unwelcome and hostile. So if it's objectively over the top and everybody would think, this sexual harassment is going way too far, it's still not illegal if the person who's experiencing the harassment doesn't, him or herself, find it subjectively unwelcome.
Okay.
And vice versa.
So somebody else can see it and think that it's sexual harassment, but if the person themselves doesn't think so, there's really not an issue? I mean, is that the way that it is?
Well,
because somebody else could probably say, look, I know this person doesn't feel like it is, but I'm uncomfortable watching it. So what would they do? Do they have to go directly to the employer and say, look, stop this?
Yes. When the subjective component is for the person who's complaining about it. So if you see another person in the workplace being sexually harassed and it's making you uncomfortable, you think it's illegal and wrong, you should report that to your employer, and then there are some protections there.
If you can, Brian, just boil it down then for the listeners. What does constitute unlawful sexual harassment? If you can put that in one answer, what does constitute that? Because I imagine, I've talked about this before on the show, some of the other things that we talk about, like discrimination, I'm sure a lot of people listening can say, well, that's never happened to me. But I do think a lot of people listening have either been harassed or they've been in a situation where they've seen somebody harassed. So I think this is something that really hits home with a lot of the listeners. I think it hits home with pretty much anybody who does go to a job Monday through Friday, that this at some point maybe at least crosses into your mind that you think something is going on. So what does constitute unlawful sexual harassment?
I think you're absolutely right about that, Ross. The straight answer is it's objectively and subjectively hostile and unwelcome behavior related to sex. And so an example of that would be what's called quid pro quo, or a sexual proposition. One time, right there, that's illegal, cannot do that, violates the law.
And that one should be obviously obvious to most,
exactly.
Right? But it would be the other type of harassment where maybe it's, things like, I don't know, posters hanging up or unwanted comments. Maybe that's a little bit more of the gray area where it's a little bit more difficult to decide what is and what isn't.
Right, or even a series of jokes or comments or a relationship between an employee and another employee. Sometimes that can start off as innocuous and get to the point where it crosses the line to being sexual harassment.
Now, Brian, I know you can't necessarily really talk about specific cases. Again, Brian Rochel joins us with Halunen and Associates. Don't forget the website, halunenlaw.com, HALUNEN law.com. You're listening to the Legal Journal on Business 1570. Ross Brindle with you once again on this Saturday morning. Brian, I know you can't specifically maybe talk about specific cases, but I imagine that harassment claims and harassment cases are things that yourself at Halunen Law deals with on a fair amount. So if you don't mind, maybe give me some type of an example where this has happened without obviously naming people's names. And if you don't mind, the process of what somebody does if they feel like this has happened to them. Is it as simple as just picking up the phone and calling Halunen and Associates? How does that process work? So it's kind of a two-part question. If you can, maybe start with some type of an example or maybe a type of case where you've seen something like this.
Absolutely. A case that comes to mind is we represented a woman who worked at a store and had a good relationship with her supervisor. It was an informal working environment. There was a lot of maybe inappropriate, sexually inappropriate jokes going on that everyone, including our client, took part in. But eventually that got that crossed the line, and the supervisor was touching and grabbing the employee, and she complained about it. Now,
so it went much further than just those comments where maybe at the beginning she was participating in it thinking it was innocent and good fun, but then from there it went on.
That's right,
Okay.
and she made it clear that it was unwelcome.
Where did that person go from there? I mean, what is the process? Because I imagine for a lot of people, too, this could be a scary thing, because for some people, the prospect of losing their job is that scary. They might rather put up with it than go through some type of legal fight, but if it's wrong, it's wrong.
That's right. In that instance, I would always encourage an employee to reach out and seek legal advice because the details matter. But generally speaking, it's a good idea to report the behavior to the employer and make it clear that you think that it's sexual harassment. Don't beat around the bush and say, just make it clear what you think is wrong and give the details.
Is that the number one maybe mistake that you see people make, is that they maybe necessarily never talk to the appropriate people at work, where they just it goes on too long, it festers, and it gets worse solely because maybe from the get-go they didn't make it either. Maybe not that they didn't make it clear enough, but when something was happening, maybe they didn't take the appropriate steps to kind of stop it from happening. Is that maybe the number one mistake or issue that you see in dealing with these types of cases?
Well, sort of. The two mistakes that I see sort of go hand in hand, and they're very related to that. One is employees who just quit their job rather than address it, rather than seek legal advice or complain to their employer. And the law basically is very harsh on employees who voluntarily quit their employment in that situation. And the other thing is employees who, like you had indicated, don't make a report or a complaint to their employer, or even when they do, they don't make it formal or in writing, and those are the smartest things to do.
Brian, we have a break coming up here momentarily. Again, Brian Rochel with Halunen & Associates joins us. Before we go to break, Brian, I kind of want to reset just a little bit for people who are just tuning in. Again, you're listening to the Legal Journal on Business 1570. If you have a question, would like to call in, maybe ask Brian a question, 651-289-4477. You can also text 651-243-0391. Again, the call-in number, 289-4477. The text, 243-0391. Both with that 651 area code. Very quickly, Brian, if you don't mind, just reset. Let the listeners know who you are, but maybe more specifically about Halunen & Associates.
Absolutely. Brian Rochel, I'm an attorney at Halunen & Associates. We represent employees only in employment law matters, and I represent employees across all areas, whether it be negotiating severance agreements or contracts, all the way to litigating harassment and discrimination and retaliation claims.
And the easiest way to learn more and maybe get in contact if somebody's maybe experienced some of the things we talked about or some of the things we're going to talk about is just to maybe make the first step and check out the website at halunenlaw.com, correct?
Absolutely.
And that website, I'll spell it out, HALUNEN Law.com. That's HALUNEN Law.com for HalunenLaw.com. More with myself and Brian Rochel in just moments. You're listening to the Legal Journal on Business 1570. Hopefully you are having a wonderful Saturday morning.
This is Ron Stone, General Manager of Business 1570. America is facing one of the most important elections of our lifetime. As a nation, we have extraordinary economic challenges. Families are struggling with high unemployment, and now 1 of 6 Americans live in poverty. Government-run health care threatens to increase costs, decrease quality, and invade our personal lives. Government health care mandates infringe on religious freedom and have forced an astonishing number of doctors to decline new Medicare patients. Misguided energy policies have caused the price of gas to more than double in the last 4 years. America is headed in the wrong direction. Mitt Romney and Paul Ryan have the experience and conservative values we need to get this country back on track. Because so much is at stake in this election, Business 1570 encourages our listeners to support Mitt Romney and Paul Ryan for the offices of President and Vice President. We ask that you join us in voting for new leadership and a new direction on November 6th.
Today, you brushed your teeth. You skipped the floss. You combed your hair. You took the train. You did the crossword. You missed 22 across. You went to work. You had a meeting. You ate your lunch. You had another meeting. You wondered, how is anyone supposed to get any work done around here with so many meetings? You left the office. You took the train. You ate your dinner. You brushed your teeth. You did all the things that one normally does the day before a brutal EF5 tornado rips through town, leaving 30,000 people without power. You never know when the day before is the day before. Prepare for tomorrow at ready.gov/today. Brought to you by FEMA and the Ad Council.
The Legal Journal on Business 1570. Welcome back. Time for my weekly Sam Waterston reference. It is my goal one day. I know Sam Waterston, not a real attorney, but just one day I'd like him to sit down and do the show with me and act like he is. I gotta think after doing Law & Order for, 20 years, he'd be able to answer some questions and be fairly legal about them. So that is my goal. As much as I like you, Brian, it would be nice to maybe see Sam Waterston in here one day.
My goal is to be as much like Sam Waterston as possible.
Well, how about that? How about that? He would scare me, and I was on TV. I'd be like, man, can you imagine if that guy was real? I don't know if I'd want to be in a courtroom with him. You're listening to the Legal Journal on Business 1570. If you want to comment, 651-289-4477. You can text your question too. A little more anonymous than the phone. 651-243-0391. Brian Rochel with Halunen Halunen and Associates joins us in studio today. The website is halunenlaw.com, HALUNEN law.com. Typically in the second half of the show, Brian, we spend so much time on stuff in the first half that it leaves me to kind of bullet point stuff in the second half of the show. So I'm going to hit you with a lot of different questions. They might not always follow any rhyme or reason, but as you told me in the break, you are quite comfortable with that. So if you don't mind, let's just hop into some of these questions.
You're keeping me on my toes, Ross.
Well, that's good. Let's start with retaliation. Then we'll go into maybe just a bunch of general, around-the-clock questions. What should you do if you think you're being discriminated against by your employer if you complain? So maybe you complain about something like sexual harassment, and maybe you do that on a Tuesday, and Friday morning comes or Thursday morning comes and you're let go. I imagine in that situation, again, if you could prove it, you probably do have a pretty good case there.
That's absolutely right. In that instance, you should reach out and contact an attorney. And just to back up a little bit, if before you're terminated you feel like something illegal is going on, it's always a good idea to complain and complain in writing. And if the situation isn't fixed, continue to complain.
And it's easy to say you complain, but if you did it, obviously you would probably say do it verbally. But what you're saying is if you do it in writing, you basically have handwritten or typed proof that says you did complain, which would make, in return, your job a little bit easier, but also protects that employee a little bit more as well.
Exactly. It protects the employee, and it gives the employer an opportunity to address the problem.
So, along with that, can you get fired for complaining about something? Maybe you end up complaining about something, and let's say maybe it wasn't even illegal, but you get fired, so to speak, just because your employer says, I don't want to deal with this person anymore. What about that? Is that something that's illegal?
Yeah, that's a great question. It's only illegal if what you complained about was illegal.
Okay.
Exactly. So if you complain that you don't like that your boss is an idiot, or you don't like the way that they're running the company, and then you get fired, that's not illegal, and it's probably not even that bad. But if you complain that there's discrimination or some type of harassment taking place, and then you're fired, employer can't do that. That's illegal. And in a similar vein, Ross, if you see something that you suspect is illegal or a violation of a regulation, and you raise that to your employer, you're protected in that instance.
Okay.
You can't be terminated for that.
Now I'm going to go to the area that I talked about, just a bunch of miscellaneous and very interesting questions and things to talk about. In the past on this show, we've talked about the Family and Medical Leave Act. If you don't mind, can you reset what that is, maybe for listeners who are new to the program or people who are just tuning in and what that does for maybe the employee.
Right. And the short and sweet of it is the Family and Medical Leave Act, or commonly referred to as the FMLA, is a federal law that guarantees employees a certain amount of time off. You get up to 12 weeks of job-protected unpaid leave. What that means is your employer doesn't have to pay you your salary during the 12 weeks. The 12 weeks have to be within a year.
Okay.
But you are the employer is required to protect your job benefits if you have any health insurance, things like that.
So what does that all entail then? One thing I imagine that goes with maybe somebody being pregnant, but are there other things that go with that? Maybe a longer term illness. Maybe you have something, heaven forbid. I don't want to wish bad upon anybody, but maybe you have a heart attack, some type of cancer. Is that what goes along with that? That's
exactly what goes along with that. It protects with relation to the birth or adoption of a child, as you had indicated, maybe pregnancy, but then also caring for the child after. And then also what the law calls a serious health condition. That includes heart attack, like you had indicated, maybe a broken leg. Okay. All sorts of things fit under the serious health condition. And an important thing to keep in mind, too, Ross, is it also protects to care for a family member's serious health condition as well. So maybe your child or a loved one has a serious health condition. You can take FMLA in those circumstances.
So it doesn't directly have to be to you, as long as it's reasonable, maybe within your immediate family, as you talked about. Maybe it's a spouse or a child.
Exactly.
Let's talk about an employer's obligation with respect to a pregnant woman. We talked about that. Is that basically what the Family and Medical Leave Act is, or is that a little bit different, or does pregnancy fall under that umbrella?
Pregnancy and the birth or adoption of a child falls under the umbrella of the FMLA. There's also a state law that covers it, but it's less expansive than the FMLA. It's only 6 weeks. And in addition to those protections, it's important to point out that an employer can't discriminate against or terminate employees who are pregnant. So if you see an employer treating pregnant women differently than other women, or an employee gets pregnant and the employer says, I don't really want to have to deal with this, and terminates an employee, that's illegal too.
And that's discrimination then.
Exactly.
Let's talk about this. I know you mentioned sick leave, so I think that goes along right with that, right? Family and Medical Leave Act, or is sick leave a little bit different as far as maybe accumulating sick time?
Yeah, sick time is a little different. Remember, with the FMLA, it has to be a serious medical condition. Okay. So for sick time, there's actually no law guaranteeing an employee sick leave or sick time.
Okay.
What there is in Minnesota a law that says if an employer does grant you sick time, then you have to actually give them the sick time that you granted, or let them use the sick time to care for a sick child. And again, those are complicated and nuanced areas. So if that's going on, I encourage somebody to speak to an attorney.
For a lot of what you deal with, Brian, and again, Brian Rochel with Halunen and Associates joins us. HalunenLaw.com is the website, HALUNEN law.com. For a lot of things that you deal with, are there different state and federal regulations for a lot of these things? And if there are, is there always one that supersedes the other? So let's say both the state and federal have the same law about something. Is there one that the employer has to follow? Is there one that supersedes the other? Did that question even make sense?
That question makes a lot of sense. It's a great question, and the shortest answer to it possible is yes, there are different state and federal rules, and generally speaking, what the law says is if a state gives more protection to an employee, then the state law applies.
Okay.
But if the employer always has to follow the federal law, and if the state law gives more protection, then the employer has to follow that state law too.
So really, these laws, to the best of their ability, do protect the employee.
Right.
An employer can't take the lesser of the two.
That's exactly right.
They're always going to have to take the more, or follow the one that's, I don't want to say tougher, but the one that protects the employee more.
That's right. And in Minnesota, there are a handful of laws that go beyond the federal laws to give additional protections to employees.
Here's a question we've touched on before, and I think we spent a fair amount of time on this a few weeks back on the program, but I think that this is a very interesting question because to me, I think there is a right answer to it, but just because I think it's right doesn't technically mean it's the legal answer. Is an employer required to tell an employee why he or she was terminated? Do they have to say, Brian, here's why I'm letting you go? Do they have to do that, or is that something they can just say, Brian, pack up your things and go?
It depends.
Hopefully they're not that harsh about it.
Right.
Yeah.
It depends. Generally speaking, no, an employer does not. However, the exception to that is there is a law in Minnesota that requires an employer to give an employee a reason only if within 15 working days an employee requests in writing that the employer provide a written reason for termination. So if the employee doesn't request it, the employer doesn't have to give it.
And is that within 15 days of being let go? Correct?
Within 15 working days of the termination.
I was going to say, this isn't some weird legal rule where you had to somehow know 15 days before you were let go, right? So it's post-termination.
It is, but that's a short period of time, and people need to be aware of that.
Okay, so basically, if you are listening today, and maybe this is the first time that you've heard this, it's a good thing to keep in your mind. If you want to know and they don't tell you, you can still find out. You don't have to go through the rest of your life not knowing. You just have to do it within 15 days.
15 working days,
15
exactly.
working days. Yep. And is that something where it's, when you say written, can that be an email, or is that a letter you basically type out on an 8x11 and you send it through the mail? Or is there a legal way you have to do that?
Anything in writing will suffice to meet that.
Okay. How about this? Can an employee, this one is very interesting because I think we all work with people who maybe do smoke at the workplace, at their job. Can an employee be prohibited from smoking on the job? And what about off the job? So in general, can my boss say, I don't smoke, but can my boss say, Ross, sorry, you're taking too many smoke breaks, or I just don't like the way it smells. I don't like people who smoke, period, so I'm sorry, you can't smoke here. Can they say that?
For the most part, yes. There was one thing you said that wouldn't be okay, but yes, an employer...
That I don't like smokers?
Exactly,
Yeah.
Exactly. An employer can prohibit smoking on the job. In Minnesota, we've got this crazy law that says that an employer can't prohibit smoking off the job, and it's called the Lawful Consumable Products Law. And it basically says employers can't take action against employees for anything that they do outside of work. That's as long as it's legal.
That's legal.
So you can't say, Ross, I don't like smokers, don't like that you smoke at home, you're fired.
Okay.
And that's actually the law that the Williams Wall, if anyone's familiar with that case, when they sued the NFL, they actually sued under that law.
Star caps.
It's star caps, exactly.
I do remember.
Exactly.
That actually brought back a good reference, by the way.
Thank you very much.
I had forgotten about that, and that waged on for what seemed, I think, the better part of 3 years. Very, very good reference there.
Sure did.
We that's going to be a tough one to get past. Now I'm just thinking about all the NFL stuff. Can an employer refuse to hire somebody based on a criminal conviction? So say maybe through a background check they find out that this person's had a criminal past. Can they say, sorry, we're not going to hire you?
Yes, they can, and that's the subject of a lot of confusion, I think, among prospective employees, is employers can say, no, we're not going to hire you because of your criminal conviction. However, there are two important exceptions to that, and again, if an employee is turned down for a job because of a criminal conviction, I encourage them to seek legal advice, because there are some laws saying employers can't have blanket prohibitions, saying nobody can ever be hired. There's some law out there saying that has a disparate impact on race. And then there are Minnesota laws that have certain technicalities when you're applying to a state employer.
The website is halunenlaw.com, halunenlaw.com, HALUNEN law.com. Brian Rochel joins us this morning with Halunen and Associates. If you'd like to contribute to the show, 289-4477. That's 651-289-4477. You can text as well, 651-243-0391. That's 651-243-0391. And don't forget, you can always listen if you're in the car. You can always listen when you get home, business1570.com. There you can also download the app for your iPhone or Android as well. Also available on iHeartRadio. Again, business1570.com is the website for that. Along with the criminal conviction, I don't want to say this goes hand in hand, but it I guess in a way it could. Can an employer require their employees to take a drug test, maybe either before they get hired or maybe during their process of being employed?
Yes, they can. Minnesota actually has some very, very stringent laws on drug testing. I think the most stringent in the state. But the long and short of it is, again, seek legal counsel if you're directed to take a drug test. But employers have to have a written policy in place before they can require employees to take a drug test, and they have to follow that policy.
Okay. Let's jump to equal opportunity employer, if you don't mind. If you can speak on that a little bit. I know at first, it was years ago, but when I first started looking for employment, I would see these things on websites that would say equal opportunity employer, or even working in the radio industry. You'll hear those on ads when people are looking for other people to come work at their place. That was a poorly phrased question. Can you tell I'm in radio? I just wing it.
Just let it go.
Yeah, equal opportunity employer. Can you talk a little bit about what that is and why it's so important? Because I know it's a huge legal issue.
Yeah, an equal opportunity employer is basically an employer that agrees to abide by the rules set forth in Title VII and the other Equal Opportunity Age Discrimination Employment Act, basically that set of federal laws that protect employees. We talked a little bit about it before, but again, it's the laws that protect employees based on protected class, like age, race, religion, things like that. And it's very, very important because those are the rules that protect all employees across the country, regardless of what the state laws are, from that type of discrimination or unfair treatment from their employer.
And Brian, does a company have to disclose that? So let's just say I saw a random business and I just wanted to apply there. But let's say when I applied there, could I say something like, "Are you an equal opportunity employer?" Can I see past jobs that have been open and maybe who filled them? Is that something that's available to the average person?
That is subject to some uncertainty. Generally speaking, no, not necessarily.
Okay.
But if the employer does disclose it, then you may be able to.
Okay, then you may be able to.
The important thing, though, to highlight there, Ross, is that even if an employer opts not to advertise themselves as an equal opportunity employer, they're still subject to the same exact federal laws. So I can't avoid being liable for sex discrimination just because I tell people I'm not an equal opportunity employer.
So that goes back to what we talked about earlier, though. You have to follow basically again, not harsher of the laws, but you basically have to follow the law that most protects the employee, and that would kind of go hand in hand with that.
Sure, yes.
If you don't mind, Brian, I want to make sure we touch on this briefly because Election Day is now just a few days away, and I want you to comment on this if you can. Let's say, and this actually does kind of apply to me, not necessarily because I can find time to go vote. But in Minnesota, I believe the polls are open 7 a.m. to 7 p.m., and I might be off on that a little bit. But let's just say that that's what it is. Mm-hmm. Some people actually do work a day like that. They're up at work by 6:30. Before they know it, it's 7:15. That person in that case would miss all day Tuesday to vote. Is there a way that they can make sure they go vote and not be, held responsible by or basically have it held against you is what I'm trying to say. Does your employer have to give you time to go vote? Do you even know the legalities on that? Can you speak on that a little bit?
I can, yes. The federal law requires that employers allow employees to go vote. So if in that instance, Ross, your boss was telling you need to be here for throughout the entire duration of the voting day, and you opted not to vote early or to do an absentee,
sure,
and you left to go to the polling place over some type of a break, your employer couldn't take adverse action against you, like firing you for that. No.
But at the same time, you probably couldn't take 5 hours and say I was voting, right?
Exactly.
It has to be reasonable.
Exactly.
And then along with that, this to me is very interesting because I've heard a lot of people talk about this because obviously we all have friends and everybody talks about things like elections. But let's just say you're in your normal office setting. Let's just say it's some type of a sales job, and the person next to you has 15 Barack Obama posters or 15 Mitt Romney posters, and they're talking about them all the time. Can somebody who maybe sits next to that person be like, "Hey, can you chill it with the Obama stuff? Can you chill with the Romney stuff?" Is that something you could take to your employer and say, "I'm tired of hearing Bob talk about this person all day long," or I don't come to work to stare at Mitt Romney and Barack Obama posters and signs all day? Is that something somebody could maybe take to a higher up and say, "I'm tired of this," or is that just nitpicking?
It probably wouldn't be illegal. And the thing to keep in mind is that in this country, the First Amendment and political speech are basically the most protected right that there is. And so an employer can't take action against an employee for exercising that kind of political speech.
We got about 6-7 minutes left in the show today. And again, Brian Rochel with Halunen and Associates joins us. HalunenLaw.com is the website. I'm going to make sure I get to as many questions as possible. Let's talk about minimum wage, if you don't mind, and the difference between state and federal. I think right now they're different. I think state minimum wage is different from federal minimum wage. And again, then which one does the employer have to follow?
Right. The employer, they are different. The employer has to follow the federal minimum wage unless the state minimum wage is higher. So that's an area where if the state gives more protection, then the state employer has to follow it. In this instance, the federal is higher. Federal minimum wage right now is $7.25. So the minimum wage right now in Minnesota is $7.25. Unless you're a small employer, which means I think less than $500,000 and no interstate commerce, then the minimum wage is $5.25.
And what about if you don't mind hours worked? I know a lot of people will hire let's just say a high school kid. Maybe they're 15 or 16. How about that? How many hours can they work? Is there a certain time of day where they have to be done working by?
I think there are particular rules when you're hiring minors about what they are. I don't know those off the top of my head, and I didn't bring those materials here. But again, in that instance, I would encourage somebody to reach out and seek legal advice.
How about this one? This one is very interesting because everybody deals with this. There's no way you can't say that you deal with this. Does your employer have a right to look at your email, whether it be your work email or maybe you're on a 15-minute break and you decide you're going to check your personal email, which is maybe not the same. Obviously, it's not the same email account, but it's on the work computer. Can you talk about that? And if your employer does have a right to basically, hack-in's not the right word, but can they basically look at it whenever they want?
Sure. I think the best answer to that question is yes. I would always assume that an employer can review your email. I want to highlight this is a complicated and developing, hotly contested area of law, and the rules are constantly changing. But the way that things sit right now, if it's an employer email system, almost certainly the employer can access everything on there. If it's a personal email system and it's on an employer's computer, again, pretty strong indication legally that an employer can look at that. So I just advise people always assume that the employer can read your email.
Err on the side of caution
Exactly.
on that one then.
Exactly.
How about this? Reasonable time for work. Say you work 8 to 4. That's your scheduled day. Or you work 9 to 5, 10 to 6, whatever it is. But say your employer, they're only going to pay you from 10 to 6, but your employer says, look, at 10 o'clock, you need to be working. So that means maybe you need to get here at 9:40, turn your computer on, make your copies, do all that stuff. Is that legal for them to only pay you for those 8 hours, but then at the same time also tell you need to get here at 9:45 so you can be ready to work at 10? How does that work?
That would not be legal. In that instance,
so that is illegal. They need to pay you for that time.
Exactly.
Okay.
If the employer is requiring you to be there and doing some type of substantive work, they got to pay you for that.
Union activities at a work site. Minnesota, most states are. Minnesota maybe more so than most. A lot of different unions. Can your employer prohibit a certain type of union activity at your work site? Can they say, look, we're glad to have you here, but no more union rallies or no more union meetings while you're working? Can that be done?
Absolutely not.
Okay.
Absolutely not. There are laws protecting any type of union activity. It's actually called concerted activity. And the courts have construed that very, very broadly, more than even just what you might think of as holding union rallies. And any type of concerted activity among employees is protected.
Interesting. I actually assume that your employer could tell you you can't do that. So it's actually good to know that. How about the employer? Can they require an employee to take a polygraph test? This one kind of cracks me up because that's another one of my goals is just to take a polygraph test. But I don't know if necessarily if that's something I would want to do for work. So can an employer tell you, hey, Bob, I don't think you're working as hard as you do. I think you're lying about it. I'm going to get you to prove it by taking a polygraph test.
Yeah.
And more so to speak, I didn't mean to cut you off there. Have you ever dealt with this? Because believe it or not, I've heard stories like this. So I know that this actually does in some places has maybe happened. Is that legal? Is it illegal?
I was actually going to address your second question first.
Okay.
I've never seen it.
Okay.
I've never seen it. I do know that they cannot employer cannot force an employee to take a test. An employer can ask an employee to take a voluntary test, but it cannot be coercive in any way.
Okay.
Job can't be conditioned on it, anything like that. And when an employee voluntarily agrees to such a test, they have to be given the results.
Okay, gotcha. That one is very, very interesting to me. Just a few moments left in the show, coming up on the close of today's Legal Journal on Business 1570. Again, Brian Rochel with Halunen and Associates joins us. HalunenLaw.com. That's HALUNEN law.com. Brian, very, very quickly, I just want you to remind the listeners who you are and a little bit about Halunen and Associates and just exactly what you can do for maybe an employee if they feel like they've been wronged, or maybe they just still have more questions. Maybe they heard something today, or maybe they even know somebody. What would you advise those people to do? And first and foremost, what is Halunen and Associates? So maybe start there, and then maybe what you would advise people to do if they feel like anything they've heard or they know somebody who has maybe went through a situation that we discussed today.
Okay, Halunen and Associates is a law firm here in the Twin Cities. We represent employees. Anytime an employee has a question about anything having to do with their work, we advise them, whether that be litigating a claim for discrimination or retaliation, or just advising somebody with respect to a contract, a severance, something like that. So what we can do to help employees really runs a broad range. We can negotiate agreements. We can file suits in court. We can file suits with the EEOC. Basically anything that involves advocacy on behalf of an employee.
Brian,
and I want to thank you, Ross, and for having me on, and the crew here in the studio. It's been fantastic.
Well, thank you very much, Brian. Very quickly, in just 15 seconds or less, if somebody feels like they've been wronged, what do they do? Is it as simple as picking up the phone and calling?
Absolutely.
HalunenLaw.com would be the place to start. HALUNEN Law.com. HalunenLaw.com. Brian Rochel, thank you very much. We appreciate it.
Thanks to everyone here.
That's Brian Rochel helping us out this morning with Halunen and Associates. Again, HalunenLaw.com. HALUNEN Law.com. That'll do it for the Legal Journal on Business 1570. We're back next Saturday morning. Thanks for listening.
You've been listening to The Legal Journal with Ross Brindle. Join us every Saturday at 9 a.m. as the top attorneys from the Twin Cities share their legal expertise with you on The Legal Journal.